come before the court is, I want to get this right, Vyrone, Finney, is that correct?
Yes, Your Honor.
Is that correct, sir? The Akron City School District Board of Education.
Yes.
Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. You should introduce yourself. You should not use the names of children or minors or victims during your argument. You can refer to folks in that regard by initials or terms like the child, should that be relevant to your argument. We have read your briefs and we're ready to proceed when you are. And I would just ask appellant, would you like to reserve time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes, please.
Very well. Then we may begin when you are ready.
Thank you, Your Honor. May it please the court, my name is Matthew John Markling, and I represent Principal Vyrone Finney. It's an honor to be in front of you. I'd like to address 4 issues. First, the instant action is not moot. Second, to the extent that it is moot, the 3 exceptions apply. Third, the subpoena definition in 3319.16 has the same common meaning that's in Civil Rule 45A1B1 and 2. And finally, this honorable court has the opportunity to avoid an absurd result. First, I'd like to address the issue of mootness. This matter is not moot because there's still an active controversy. Mr. Finney has an appeal that is currently before the trial court. And on appeal, he has the right to reinstatement and monetary damages.
Can he get a new hearing?
Nope.
So why is it not moot?
Because if it is determined that the violation of 3319.16 was violated, then as a matter of law, Mr. Finney is going to be reinstated because the board, Judge Carr, is required to strictly apply 3319.16 because General Assembly and the United States Supreme Court have made it very clear that employees such as Mr. Finney are entitled to notice and an opportunity to be heard. And in a 3319.16 hearing, that requires strict compliance. If there isn't strict compliance, then as a matter of law, Mr. Finney is going to be reinstated.
Well, I think I understand that. I guess I'm trying to figure out, though, if he's reinstated, what does it matter? Why does he care about getting the documents if he's reinstated?
That's a good question that goes to the third. Why it matters is because the board is arguing that he's never going to get the documents. So this is an appeal. There is currently an appeal under 3319.16. Remember that Akron's not hiding the fact that they refused to produce documents. So in effect, Mr. Finney went to this pre-disciplinary hearing where he is entitled to cross-examine, to have the evidence before him, before he goes in, and he was only given what Akron would give him. Now, they're now arguing also that this on appeal is not a 3319, or I'm sorry, Your Honors, that is not an RC 2506 appeal. There are, now ordinarily when an individual on an administrative appeal, as the court knows, is denied the opportunity to obtain documentation or fully cross-examine witnesses in this situation, they're entitled to supplement the record and to go through an evidentiary hearing. It is the board's position to this court that Mr. Finney is not going to be entitled to that. That he is restricted, that on his appeal, he is restricted to the record presented to the referee. And that record presented to the referee was inappropriately constricted and limited to what the board wanted the referee to see. Now, I would ask, after I will supplement with the leave of court, the authority that explains why this action isn't moot. I would refer the court to Streetsboro Administrative Association, the Streetsboro City School District Board of Education, 2019 Ohio 2170, where the court explains that RC 3319.16, that process affords individuals the right to thoroughly challenge just cause determinations. Now, Judge Carr, I don't believe, based upon my research, limited based upon the mootness argument being raised 2 days ago, that the court has the right to declare a new, to go back to the referee. I believe that the outcome is going to ultimately be reinstatement because there's a violation of 3319.16. The court in Streetsboro does say, however, that RC 3319.16 permits a court the authority to grant substantive relief, whatever that relief is. Okay, the court didn't describe it, and I'm not aware of a situation where that would apply. Now, this is not moot because, again, as we explained, this is ongoing. If this court were to find that 3319.16 was violated because the subpoena were refused, then it will be remanded. The same court has this case on appeal, and the case will ultimately result in Mr. Finney being reinstated. I also have...
Counsel, okay. I'm trying to follow this argument. So you're saying that it's not moot because the same court will have it, but will there be any, let's say that we were to determine that there was an entitlement to these other subpoenas, right? The documentary evidence that you're seeking. Could that be utilized by the court? Could that be somehow considered by the court?
Yeah, it will have to be, that will be considered by the Common Pleas Court. The Common Pleas Court will now have a ruling from this court that says that as a matter of law, Mr. Finney was entitled to the definition of...
But you're saying he's going to get what he wants anyway.
Well, I'm concluding that it's not predisposed, that this is not done. Our argument is going to be that he is entitled to reinstatement. That's going to be our argument. The case is not done. And it'll be incumbent upon the board to argue why that wasn't one of many procedural violations.
Were any of the people that the appellant sought to have subpoenaed to appear, were all of those granted? Were all of those provided by the board?
Yes, but I want to make it clear that that's the distinction that we're kind of getting to, is that it's an absurd result to think that the word subpoena only means that you appear.
I just want to make sure. So all of those requests occurred?
Yes.
Okay.
The documentation relating to their testimony was not produced. So next, to the extent that this is moot, the 3 exceptions to mootness apply here because it is capable of repetition, yet evading review. Clearly, it was a short period of time. Ironically, it is still ongoing. And there's a reasonable expectation that Principal Finney will be subjected to the same action, that being that he'll be denied the right to get the documents pursuant to a subpoena. Akron admits that. In their motion and their brief to you, they're admitting that he's not going to get these records on the administrative appeal. So it is, not only is it a reasonable expectation, it is totally expected. The second exception is that there remains a debatable constitutional question to resolve. Clearly there's a constitutional question here, and whether denying Mr. Finney the right to have documentation prior to his hearing amounts to a deprivation of his right to notice and opportunity to be heard. And third, whether this is a matter of great public interest. And clearly it's a matter of great public interest. I can't even, I'm going to jump, if I could, to my fourth argument about the absurd result. If this honorable court agrees with the trial court, an absurd result is going to end up happening. That means that every board, when it has a 3319.16 hearing, every board will only produce to the referee the documents that the board wants to produce to the referee. The board will refuse to produce teachers, non-teaching employees, administrators, treasurers, superintendents with any records that relates in any way to the underlying discipline unless it's what the board wants them to have.
And Counsel, I just want to let you know that you are moving into your rebuttal time.
Thank you, Your Honor.
Sure.
That result is the antithesis of notice, opportunity to be heard, and due process. It should not be a surprise that the referee would have found in favor of the board in this case. Can you imagine a criminal case where the defendant isn't entitled to any evidence, to cross-examine any witnesses? Of course that would be the outcome. It will be the outcome in every termination hearing. If plaintiffs or employees are denied the opportunity to require individuals to attend under a subpoena. And then finally, I know I'm...
But you said that people who were subpoenaed and required to attend, they were required to attend, correct? Those subpoenas were issued.
Your Honor, the subpoena was a subpoena for the individual to attend and produce records. The individuals attended, but they did not produce records.
Right. Okay.
Now, we've briefed the issue. I would just, I think a plain reading of 3319.16 is in order. 3319.16 states that requires the presence of witnesses upon subpoena to be issued by the treasurer. Now, the board wants to totally ignore what the definition of subpoena means. Subpoena has multiple meanings, but it's common. We all know that subpoena has two meanings. One, to attend and give testimony, and to produce documents and electronically stored information. Now, the board is arguing that the statute doesn't say a subpoena ducis tecum. It doesn't have to. It doesn't have to say subpoena ducis tecum because a subpoena, by definition, includes requiring you to attend and, if the party wants you to bring documentation. I've briefed that in front of you. You have that argument. I have only 2.5 minutes left, and so I will reserve that time unless the court has any questions for me at this time. Thank you.
Thank you.
Good morning, Your Honors. May it please the court. My name is Alejandro Cortez. I'm with the law firm of Retzel Mandrast, and I'm here on behalf of the Akron Public Schools Board of Education. I'm going to start by addressing the merits first and then going into the mootness issue. We've heard an argument that the trial court was wrong because they didn't apply the common and accepted definition of the word subpoena. Well, it's well settled in this state that courts apply statutes as they are written, giving effect to the plain and unambiguous words of the statute. And this is what this appeal is about. It is about the court's construction of the statutory termination procedure afforded terminated teachers in 3319.16. The first part of the statute sets out the statutory procedure for terminating a teacher's contract and importantly affords that teacher the right to a hearing. The second part of the statute addresses the hearing itself. And among other things, the parties may require the presence of witnesses on their behalf upon subpoena to be issued by the treasurer of the board. There is no need to construe the word subpoena. The General Assembly expressly told all readers, courts, anyone who's construing this statute as to what is the subpoena authority of a treasurer of a local school board in this context. In this context, the treasurer may issue a subpoena to compel the attendance of witnesses at these statutory hearings. Counsel for the appellant makes a deal out of that it doesn't have to say subpoenas duces tecum. It actually kind of does, because again, the legislature communicates through the words used. It is specifically critical to this case that they only reference the presence of witnesses, not the production of documents. I believe in other statutory sections of the revised code, for example, RC 169.08C, they specifically state that the director may issue subpoenas for any witness or a subpoena duces tecum to compel the production of documents. It is presumed by courts that the General Assembly knows what it is doing when it passes statutes. If the General Assembly wanted treasurers in this context to have the authority to issue subpoenas for the production of documents, it would have used word to that effect.
So your position is the educator has no ability to have documents produced at these hearings?
That is not the position. My position is that under the statute, it does not offer.
Well, that, under the statute, we're proceeding under the statute, you would say to us, and it's okay, and I understand your argument is there's no ability to have the record produced by subpoena.
No, not in the statutory context. But that does not foreclose the avenue to get the documents that he purportedly thinks that his client has not gotten. As mentioned in the brief, a voluminous public records request was sent to the board. Over 800 pages of documents were provided to council. For him to come before this court and say that Akron, the school board, has not turned over any documents is an outlaw. The board has responded to the public records request. It did not respond to the subpoenas duces tecum because the treasurer doesn't have the authority. And if the appellant truly believes that there is a right under this statute for the production of documents, he had recourse in law. He could have filed a mandamus claim against the treasurer to force him to comply with his quote-unquote clear legal duty to issue a subpoena duces tecum. That is how questions like that are supposed to be answered, not by filing baseless applications to enforce subpoenas that were never even served. In addition to that, he could have filed a writ of prohibition to this court or to the Ohio Supreme Court to stop the trial court from ruling on the issue until the mandamus action was resolved. Again, there was adequate process here for the appellant in this termination proceeding. I find it quite telling that in no brief filed with this court or even with the trial court, the appellant can cite to any case where the lack of a production of documents in this context has been found to violate someone's due process. And as the court kind of touched on earlier, there is no hearing. There is no right to a remand of a hearing. The statute is pretty clear. It's a reversal or a modification of the award. I don't even believe the trial court has the authority to conduct a trial de novo on this issue on the current administrative appeal. So this goes into the mootness issue. Mootness does not go to whether or not the termination of the appellant is complete. The mootness issue goes to the issue that we have on appeal. Whether the first issue is, was the trial court incorrect in dismissing the application? If not, then the next operative, if it was, the next operative question is, okay, well, if it committed error, how can this court carry that judgment into effect? How can this court's judgment be carried into effect? It cannot. The hearing has been held, the referee issued his report, the board upheld the termination. We're currently on a statutory appeal pursuant to 3319.16. If the court was wrong, which it was not, this is a hypothetical judgment. There's really nothing that this court can do to remedy the alleged violation claimed by the appellant. And again,
Well, counsel, he's indicating that that might be of significance to the court in reviewing the 3319.16.
I think it would be,
That just the fact that the board didn't comply.
yes, I mean, if I were in his shoes and I was in his position, my argument would be, we are entitled to a reversal because they did not provide the documents. There was not a fair hearing. So again, he's going to find relief here, relief in the situation through other avenues, but not through this court, because there is no effective judgment that the court can provide. The courts decide live controversies, actual controversies. At one point, there was a controversy between the parties on the subpoena issue. It has been rendered moot, and the matter should be dismissed on that basis. But again, I understand matters should be decided on the merits in most circumstances. So we don't have to get to the mootness issue, but we did believe that it was important to bring it to the court's attention. And independent of the merits, each issue can be decided separately from one another. So here today, based on the merits of the legal issues, there's simply no need to construe 3319.16. It is unambiguous, and when a statute is unambiguous, you apply its plain meaning. And when you look at it,
Can I stop you?
Yes.
I'm so sorry, but I want to make sure I understand the foundation here of this case. So there was a hearing, the request was made under 3319.16 for subpoena duces tecums, obviously, and the treasurer did not issue the duces tecum, but did issue the subpoenas.
yeah, he issued the subpoenas for the presence of witnesses at the hearing. In addition to the subpoenas duces tecum, the appellant also had submitted subpoenas for witnesses to appear at a place other than the hearing. The statute is pretty clear that the subpoena is for the presence of a witness.
I remember reading that. I just want to make sure, then, while the hearing was pending, then this action was filed in the common pleas court.
Yes, before the actual hearing was started, the appellant did make a motion to continue with the referee, which was denied. And at that point, there are avenues within the legal system that the appellant could have used if he believed that his rights were being violated by moving forward with the hearing without the documents. He could have filed an injunction, he could have filed, like I said, a writ of mandamus to compel the treasurer court, a court of competent jurisdiction would have decided right then and there whether or not the statute requires the production of documents.
Counsel, that's what I was wondering. What is the cause of action they actually filed?
You don't believe there is a cause of action, and that's why, that's
Did
what,
anybody raise that as an issue?
it was, I mean, the court ultimately dismissed, applying the plain meaning of the statute, the trial court found it didn't have the subject matter jurisdiction. As this court knows, it's well settled that the jurisdiction of courts is conferred by the Constitution or statutes. So in this situation, 3319.16 creates a special statutory proceeding that confers specific limited authority onto the trial court. And the trial court saw that the relief requested by the application filed by the appellant exceeded the court's jurisdiction. Because again, it was limited to instances where a subpoena is issued, and when someone fails to comply with that subpoena and does not appear at the hearing, the court has the authority to institute or conduct detachment proceeding and find that person in contempt until they comply. Again, yes, so. So again, just to wrap it up, the court was correct that it did not have the jurisdiction to proceed to award any relief in this matter requested by the appellant. Again, RC 3319.16 is unambiguously clear, and in situations where a statute is clear, a court impermissibly deviates into statutory construction into the meaning of a statute when it's clear. So there's really no need, and it would be against well-settled case law to construe a word that is completely and appropriately defined by the context of the statute. Thank you.
Thank you.
Unless there are any other questions.
Any questions? Thank you, counsel.
Thank you.
My 2 minutes left, I'd like to quickly address some misrepresentations. Number one, there's no evidence in the record as to response to public record requests. In fact, that's why subpoenas were, Dukas Teekum were issued. Second, I'd like to misstate the remedies, the relief sought. In fact, Principal Finney did exactly what 3319.16 requires. 3319.16 says that when a party feels that a subpoena is not being complied with, it needs to file an action with the Common Pleas Court. So Judge Carr, you asked what action was filed. The action that was filed was an action under 3319.16 to enforce the subpoena, which requests attendance and the production of documents pursuant to 3319.16. And then when that was denied, an appeal was brought. So it's a kind of a circular.
I'm sorry, could you file for injunctive relief as part of your complaint?
We did request that the proceedings below be stayed, and the trial court denied those proceedings, denied that request. And so it is not, while it is, again, this is a circular argument, the procedure that is required statutorily was followed. The trial court simply found that the subpoena in question didn't include both attendance and presenting exhibits. I would also like to say that counsel's correct. There's not one case that deals with 3319.16 in a board's refusal to produce exhibits. I've been practicing this area for almost 30 years representing school districts, and I'm not aware of any district ever doing what Akron has done. The reason there's no case is because no district other than Akron takes this position. The court will not find a case where a district blatantly refuses to produce any records that are requested by the employee in their defense. That case doesn't exist. And in 30 years, this is the only situation that I'm aware of. And as was stated by counsel, he is admitting to an absurd result. And that is that he is submitting that when this goes to when this is before the trial court is not going to be able to do a de novo review, and the trial court is going to be limited to whatever evidence is in the record.
Counsel, I'm going to have to ask you to wrap up, but I want to ask you a question before I do.
Yes, Your Honor.
Can you respond to the comment regarding the remedy being an original action from the treasurer?
That is what happened. That is the remedy.
A mandamus action.
It's not a mandamus action. It is a motion, well, that is what was submitted, is a motion to compel the production of the record. That is what was filed, and that's what's being appealed.
I know, can you respond to explain to me why a mandamus action wasn't the proper remedy there?
Because specifically, 3319.16 in the statute says that in order to enforce a subpoena, you bring the action in front of, you bring in an action to enforce it pursuant to the common pleas court of the jurisdiction in which the action relies. I am out of time. Does anyone have any questions? So we request that this court reverse the decision of the trial court and find that Principal Finney was intended to have both the subpoena means both the attendance of witnesses and the production of records as requested. Thank you.
Thank you, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The Board of Courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website.
Thank you.
Thank you, Your
both
Honors.
again.